Welcome to The Breakaway with David and Fabian. Today our guest is Ryan Heath, a constitutional lawyer. Let me read a little bit about Ryan and then we'll introduce him. He's a civil rights activist and an Arizona attorney. He's a founder of Heath Law. He also runs an anti-woke nonprofit called the Gavel Project. He's a constitutional expert, and upon graduating, he received the Community Changer Award, recognizing his commitment to excellence and integrity as demonstrated by community involvement. Thank you so much for being on, Ryan.
Thank you, Fabian. Thank you, Dave, for having me. I'm excited to be here, talk about the law, talk about our rights, and hopefully provide a little bit of education. But before I jump in real quick, none of this is legal advice. So anything that I'm saying today, I'm not speaking to any of my clients. I'm simply trying to provide some background information on how the law works, what it is that your rights are, and what we can do to stand up to the tyranny that we're facing right now.
Absolutely. And I did want to ask for people listening, can you explain exactly what is a constitutional lawyer?
Yeah, so Constitution, I've got this book here. It's basically the selective writings of the Founding Fathers. It's not just the Constitution, it also is the Federalist Papers and a number of other documents. But our society, we live in a federalist republic. That's what our government actually is classified as. And what that means is that we have a constitution, and that constitution governs foundationally how our government works. It sets limitations on what the government can do. It tells the government that if you do this, there are going to be consequences for the people. And that allows us to assert our rights as established by that constitution to make sure that the government doesn't overstep and actually infringe upon our basic human rights. And that's really what the Constitution is. And as a constitutional attorney, I take on cases wherein we make challenges to laws, we make challenges to the way the government has treated people based on the precepts established by the Constitution. And so if you understand the way the government is structured, every single law that is passed after the Constitution needs to be in accordance with the way the Constitution is written. It needs to comply with those mandates. Anything that exceeds that authority or any government action that goes beyond what is prescribed by that document is unconstitutional, and you can strike that down in a court.
First of all, when I wanted to go to law school, one of the main things I wanted to study, of course, is constitutional law. And because I don't think there's anything better than protecting individuals' rights, especially when the government tries to infringe on them. So I want to take you towards something. Now, first of all, you're based in Arizona, correct?
Right. So I am an Arizona attorney, and I have a nonprofit that has a number of cases out in California. So we hire attorneys out in California to represent the interests of our clients.
Got it. So let's, we can talk about a lot of stuff regarding a lot of things that are happening with elections, right? But maybe I want to first actually start with talking about this war on parents that we've seen, specifically when it comes down to parents wanting a say in how their kids are being educated and what is being provided in the schools. So a couple years ago, and this was already when Biden was president, we saw a lot of parents, regardless if they're Republican or Democrat, go to school board meetings and be really pissed off at the fact that, essentially they're providing material or trying to do courses that a lot of people disagree with. But the DOJ, Biden's DOJ, essentially targeted, it seems like, parents' rights to go to these school board meetings. Did you have any participation in that, or or what is your overall opinion about that?
Yeah, so I have seen that firsthand. I've been doing this since 2021 is when I launched the Gavel Project, about a year after passing the bar. And I've been deeply involved in those issues in a number of ways. So actually, one of the board members for the Gavel Project is one of the parents who was the first parent targeted by the FBI in these unconstitutional oversteps by that organization to target parents. His name is Kelly Walker. He's a great man. And they literally were going after parents for just standing up for their kids, not wanting their kids to be indoctrinated, not wanting these, woke ideals shoved down their kids' throats without their consent. And there's a pretty clear line of cases from the Supreme Court interpreting the 14th Amendment of the U.S. Constitution. And you as a parent have the right to the care, custody, and control of your child. The government doesn't have the right to come in and shove down ideas down your kids' throats that you don't want them to learn about. You actually, if it's not related to, math, science, writing, history, those types of things, there's no place for it in school. So parents should be standing up more. I'm kind of saddened by how much people have stepped back in the last few years. There was a huge uproar, obviously, during COVID and all of the mask mandates and the vaccine mandates that were coming down. But since then, it seems to have been crickets from a lot of folks. So I really hope parents get involved again, because if they don't, we're going to be looking at a situation where your kids are going to be indoctrinated. Your kids aren't going to understand right from wrong. They're not going to be able to, deal in reality once they graduate from high school and from college. So parents need to get involved now. We need to start standing up to these woke ideologues.
Yeah, I felt like exactly how you said that during that time, there was a lot of parents that went to bat for their children, and now you don't really see it as much. You do, but not to the extent that you did when all this stuff was happening. It's kind of died down. And as a parent, I would assume that you would be thinking, where can I get help for this specific? Like, I don't even know what kind of law this is potentially breaking. And of course, as a constitutional lawyer, you're who they should be going to. So can you tell us a little bit about maybe some of the cases that you're working on and what you're fighting for, and what are some of the situations that you're dealing with?
Yeah, so just a quick way of background. You mentioned that I know Justice Samuel Alito. He actually was one of my professors in law school, and I learned about constitutional interpretation from him when I was a third-year law student. So this is something that I have an intimate understanding of. And what's happening right now is that parents oftentimes, as you just mentioned, don't know who to go to or what to do when they feel like their rights are being violated, like their kids are being indoctrinated. So obviously they can reach out to myself at my law firm. We'd be happy to consult with them if they're in Arizona. We also have attorneys licensed in New Mexico, in Washington, and Texas, and Washington, D.C. as well. So if you have any issues in those states, I'd be happy to work with you. You can go to heathlaw.com to learn more. But with respect to the cases that we have right now, most of the work that I do that I'm most proud of is in California. It relates to the COVID-19 mandates. And these are kids that we represent who decided they wanted to exercise their free speech rights, their right to disagree with the government. It's actually the most foundational right that we have. It's the First Amendment for a reason. And the First Amendment protects much more than your speech. It protects your conduct as well. So if you engage in conduct that is intended to express some sort of viewpoint, and it is reasonably likely to be interpreted by an observer that viewpoint you're trying to express, if they understand what you're trying to convey by your conduct, then it's protected by the First Amendment. So there are a number of cases that have established this throughout the United States Supreme Court's history. For example, one of the cases is O'Brien out of Texas. This case involves someone who burned an American flag in a park in violation of a flag burning ordinance, and they were punished. And the Supreme Court held that because they were burning a flag, because they weren't speaking necessarily, but they were engaged in some conduct that other people would understand to be expressive, they held that that was a protected activity. There are other cases as well along the same lines. Another great case in the school context is Tinker v. Des Moines. It's a case involving a number of students who went to school wearing black armbands during the Vietnam War. And there was a school ordinance that was passed saying you can't wear a black armband to protest the Vietnam War. The students did it anyway. They were punished, took the case up to the Supreme Court, and the Supreme Court said, hey, that's expressive conduct. That's something that you are doing as a protest measure. People understand because there is an ordinance, saying you can't do this. When you violate that ordinance, everyone around you is going to understand why you're doing it. It's to protest that measure. And so those students were granted expressive speech rights in that context, and their right to wear those armbands was protected by the First Amendment. And our contention is, in these cases, these mask cases, is that when you take off your mask in the context of the pandemic, let's all flash back to 2022 when California was, the last state in the nation to require masks for kids to go to school. These students were clearly expressing their disagreement with a compelled orthodoxy on that issue. They were taking their masks off in violation of the school ordinance saying you can't do that. And they were sending a clear message. I mean, some of these kids were in 4th, 5th grade. They were stuck inside a cage for 4 weeks at Saddleback Valley Unified School District, an outside cage surrounded completely by metal bars. Wow. They were told to sit at their desks. They were put desks in the courtyard. They couldn't leave. They couldn't do anything. They couldn't join their friends at recess. They couldn't go to lunch. They could only leave to use the bathroom. And these kids sat there for 4 weeks to express their disagreement. Now we're suing personally the teachers, the principals, the school board administrators for violating those students' rights. Because when you step across the line and you tell a student they don't have the right to disagree with you on a foundational issue, such as whether or not you can breathe normally, that goes too far. And it's up to organizations like the Gavel Project, which is a 501c3 nonprofit that I run, to help those students find attorneys to represent their interests and fight back. And so that's what we're doing. We're holding these people personally accountable. And we're very excited about the prospects of litigation. We've survived a number of motions to dismiss in the Saddleback Valley case in particular. That's the Kids in Cages case. We have another case with ABC Unified School District in South Los Angeles. And in that case, our client was stuck in a closet surrounded by plastic tarps. She was a 5th grader because she didn't want to wear a mask and because she wasn't vaccinated. They were quarantining this girl against her will. She wasn't sick. She showed no signs of illness. And they were punishing the student because she was disagreeing with compelled orthodoxy. There's a really great case that I want to talk about for a second called West Virginia School Board v. Barnett. And this was a case that came out of the 1940s. So during the throes of World War II, when nationalism was an extremely important idea and an extremely important issue to promote for the protection of the United States. I mean, at that time, we were in a world war. We had to promote the ideals of patriotism. We had to do these things to make sure that our force, our nation was it was going to actually fight back on a unified front. And so the school district in that case actually passed an ordinance requiring students to stand and salute the flag and say the Pledge of Allegiance. And so there were a number of students that objected to this. And basically they said, look, you can't do this to me. But the school said, we're going to do it. And if you don't do it, we're going to expel you and you can't come back. And we're going to actually charge you with truancy as well. And so this case went all the way up to the Supreme Court. And the Supreme Court said in that case that it doesn't matter what the objective is of the ordinance. The means are irrelevant. It doesn't matter that we're in this, national state of emergency where nationalism is super important to promote. You cannot compel people to accept foundational ideals on matters of profound importance. And so because the flag that these students were being compelled to salute conveyed the ideals of patriotism, national unity, anything you can think of that, is connoted by the flag of the United States, the students can't be compelled to participate in a ceremony wherein their participation conveys the acceptance of the ideals underlying that flag. And so the same thing is true in our cases as well. We're arguing that, masking is compelled orthodoxy. It requires the individual wearing the mask to accept the idea that masks are, one, safe and effective for stopping the spread of COVID. They're not. We know that. We've known that for a very long time. And that they actually can have their personal autonomy overridden by the government. You can't do that. It's the most foundational principle that we have, the right to disagree and the right to actually express our own viewpoints on profound issues.
That's incredible stuff right there, Ryan. The question I have just talking about this stuff is, what is the argument that you usually hear the state make or the school make or the county make or the city make in regards to why they are able to triumph essentially your First Amendment rights here? Yeah,
so there are a number of arguments that have been raised in these cases. One of the arguments typically goes to immunity, government immunity, qualified immunity, certain immunity statutes that are granted to government actors under state law. And because we're suing under federal law, though, typically that's not overridden. So you can't just override someone's federal constitutional rights by passing a state ordinance or a state law saying, this person has immunity from this action. So that's the typical argument.
You're saying that they're claiming immunity against any case brought up against them, like saying
yes,
that we can't hold them accountable? Wow. So they're not even trying to argue that they have an interest in terms of public safety or anything, right? They're simply taking the immunity route.
They are arguing that as well, but generally it comes down to immunity. And, some of the cases we've seen arguments about how this was, a national pandemic, the Constitution should be set aside. But those arguments are very easy to defeat. The Constitution, your constitutional rights, do not get set aside simply because the government deems some interest to be of paramount importance or some, compelling state interest, such as, stopping the spread of COVID-19. So that's one of the arguments that we're facing. We're overcoming pretty easily. But it's a very interesting area of law to be involved in. And this isn't something that I ever thought I'd be doing. After law school, I was recruited to work for a firm out of California, doing workers' compensation defense here in Arizona. I was basically taking over their office, doing a lot of networking stuff, setting myself up to eventually become a partner in that firm. And then COVID happened and things got really wild. Obviously, I was graduating in 2020. So during COVID-19, I didn't get to have a law school graduation. But this all kicked off really when my sister was compelled to get the COVID-19 vaccination as a nurse at Phoenix Children's Hospital. And I was able to help her. I wrote 3 letters to the board of directors at PCH, threatening to sue all of them into oblivion, basically, individually, if they didn't give her an exemption. We didn't ask for an exemption. We demanded one. And the day after she was supposed to get fired in October of 2021, she got a letter from PCH saying she got to keep her job. So
Wow.
it's a very inspiring
That's a good brother
moment
right
for me.
there.
Yeah, and I mean that's an organization that does $500 million plus a year in revenues, and I was a first-year lawyer, and I beat them. So with that vote
Justice
of confidence,
Alito it seems like Justice Alito taught you well, huh?
yeah, I think he taught me a couple of things. Yeah, but with that vote of confidence, I decided to start this 501c3. I quit my job when my wife was 7 months pregnant with our second daughter, and I decided to start a charity. So that's what I've been doing ever since.
Wow.
Charity work and private practice.
So I can assume that you have a lot of people who don't like you, who are part of the state and the federal government, to say the least. And how do you fight what is essentially the system at this point? I mean, you have this massive monopoly of this lawyers, nonprofits, the federal government itself, and here you are fighting almost like a David versus Goliath situation. So what do you come across doing this, and what don't people know about the fight that you do?
Yeah, I mean, it's very scary to do what I do, but I have God on my side. I believe wholeheartedly that he has my back, and he's been watching over me from the beginning of this journey. I've been in relatively dangerous situations. I've gone to school board meetings that have been highly contentious where Antifa has been present, those types of situations. And it's important just to show that you're not afraid, to show up and actually fight for what's right. So that's what I do. I believe very much in what I'm doing, and I know that it's going to be all right at the end of the day. The thing that I really think inspires me is when people support my work. Obviously, we are a nonprofit organization. We rely on donations to pay attorneys. I'm not licensed in California, so all the COVID-19 cases we're fighting require us to hire attorneys for that work. And all the folks out there that have supported us by giving tax deductible donations has just been a godsend. And we really appreciate all the help that we have. And as long as they continue to support us, we're going to continue to fight.
Let's turn to elections, because I think we have a big day coming up. And I think, less than 40 days, yep, something like that, right? So I want to ask you something, Ryan. Yesterday, I was watching a video before I picked up Fabian from the airport. And it just so happened to be a guy that was walking through Arizona State University, coming up across a booth that was registering individuals to vote. And he asked him, how easy is it to actually register to vote? And I thought that he was implying, like, look how simple it is, because, the left likes to make that argument that, it's so hard to register to vote when you implement voter ID. And I know Arizona actually passed pretty good election integrity laws, but I was shocked to learn that you don't need to provide a photo ID or an ID at all when registering to vote if you just want to vote in the federal election. And that is specifically in Arizona, meaning you won't get the down ballot like state races, but you will still be able to cast your vote without presenting a photo ID for either Kamala, Trump, or third party. Is that true?
That is true. So Arizona, for state elections and local elections, you have to provide documented proof of citizenship in order to register to vote. But if you want to register to vote in a federal election, you can get what's called a federal only registration form, and you can simply attest under penalty of perjury that you are a citizen and that therefore you have the right to vote. Arizona is a very unique state to be litigating these election cases in. I mean, if we can just kind of back up to give you the history of how I got into this, because I think it's important. So I was hired by True the Vote back in November of 2022 to file a lawsuit on behalf of State Senator Sonny Borelli up in Mojave County. We filed a claim that relates to the signature verification statute in Arizona for mail-in ballots. So if you get an early ballot in Arizona, whether it's in person, you go to a voting center in person, or if you get a ballot by mail and you want to submit that ballot, there is an affidavit on the outside of the ballot. It's an envelope. You actually put your ballot in, and you have to sign that ballot under penalty of perjury, attesting that you are the voter that is qualified to vote in this election. And so We ended up dismissing that case voluntarily after a few weeks. We had a situation where the Cary Lakes attorneys in Maricopa County were filing a very similar claim, and we didn't want to have duplicative lawsuits going on and needlessly waste resources on litigating that issue in Mojave County. So what happened, though, very unfortunately, is that Cary Lakes attorneys are, how do I say this politely? They aren't very good. They're just not very good at their jobs. And they, in their research and in litigation, the motion practice, they lost their signature verification claim on a motion to dismiss. And the reason they lost that claim is because they failed to find binding precedent out of Yuma County from 1997 that set aside an election a year after the fact for a county board of supervisors race because the county failed to conduct signature verification in accordance with Arizona's non-technical signature verification law. So Arizona has this law, it's called ARS 16550A, and what it says is that upon receipt of the early ballot affidavit, the county recorder or the other officer in charge of elections or their designee shall compare the signature on the affidavit envelope to the signature on what's called the registration record. That's a very important term. And so if you don't conduct that comparison to that particular document, if you do that for enough ballots, meaning the more ballots than the margin of difference between the two candidates, between the losing candidate and the winning candidate, then the election is void and it has to be set aside. So they actually voided this election in Yuma County a year after the fact because the county recorder didn't conduct signature verification in accordance with that statute. And so in Maricopa County, I was hoping they would find this case law. I was hoping they would find this precedent, cite it, and actually succeed on their motion to dismiss claim, have a trial on that issue. Unfortunately, they didn't find it. And so I ended up actually suing Cary Lakes Judge Peter Thompson in the Arizona Supreme Court as a voter, as a pro se litigant. I put everything on the line. I actually risked, potentially losing a lot of my own personal property, my house, my law license, because he missed binding precedent. And so I filed what's called a writ of mandamus. A writ of mandamus is a request to the court to issue an order to a government official telling them they have to do their job. And I asked the court to tell Peter Thompson to basically take the case back from the Court of Appeals to consider this precedent that was not presented to him by either side and rule accordingly on that claim. Instead of getting disbarred, instead of getting sanctioned by the Supreme Court for suing a judge, I was actually asked by the Supreme Court to intervene in Cary Lake's case as amicus curiae.
Wow.
And now amicus curiae means that you're a third party that's not a party to the case, but you're someone outside who has a unique perspective to provide to the court for their consideration in ruling on this case. And so I ended up getting found by a very wealthy individual from Maricopa County. And he hired me, his name is David Mass, to file an amicus curiae brief on his behalf. And I filed that in the Arizona Supreme Court when Cary's case was in that court on the issue of signature verification, and I won. And I got the case sent back down to the trial court for a second trial. And that's extremely rare. It's like a 1 in 10,000 occurrence when you win as amicus curiae. And so
that's amazing.
We ended up going back down to the trial court this time after it was sent back down to try and intervene again as amicus on behalf of my client, David. And when we got there, we filed a motion to appear as amicus and an amicus brief, and Cary Lake's attorneys objected to the filing. They actually asked the court to not consider the arguments that we were presenting. And then they lost. They lost
What?
across the board. And
wait, what? Why? I mean, I'm not a lawyer, but I know common sense and logic. Like, why would they oppose that?
Apparently, they thought I was a Fed. That was what they were saying on Twitter, which is quite interesting given my background and actually spending months of my time in California teaching kids to civilly disobey their school's COVID-19 mandates, representing kids in those types of lawsuits. They just had bad information and they thought that I was, some sort of oppositional defiance or I don't know. But in any event, they lost. And then 6 months later, I think it was 6 months. Don't quote me on that. I'm not very good at math, but it was in September. A judge in Yavapai County issued a ruling on the exact argument that I had been making, and he ruled in favor of that argument. And the argument that I was making was that Maricopa County did not follow the signature verification requirements of ARS 16550A, because instead of comparing the affidavit signatures to the registration record, they were using whatever signatures they wanted to from any document submitted by the voter to the county.
Wow.
And that's not lawful. That's not the way the law works. If you're registering to vote in Arizona, as we mentioned earlier, you have to provide documented proof of citizenship. And what they're doing in Maricopa County is they're taking the 758,000 early ballots, the mail-in ballots from the primary election in 2022, and they put those into the registration record. When you submit a ballot by mail, you don't show that you're a citizen. You don't provide any identification. You don't provide any proof that you are actually qualified to vote. So that's not a registration record. And so they incorporated all of these 700,000 plus ballots into the registration record, illegally. And they use those exclusively to accept hundreds of thousands of ballots in a matter of seconds for tabulation. They didn't conduct signature verification in the way they were required to. And so Kari Lake would be the governor right now had her attorneys not objected to that filing.
Does she know this? Does she know that they did this way?
She's aware. Yes.
Wow.
So I'm not sure why this isn't a bigger story, why folks aren't talking about this, but I am still litigating this issue. I filed a lawsuit on behalf of my client, David Mast, and a Cochise County Board of Supervisor as a citizen, as a voter, challenging what Maricopa County did during the 2022 general election back in September of 2023. And then in December of 2023, I filed what's called a quo warranto action on behalf of the Attorney General candidate for the Republican Party, Abe Hamadeh. And those cases are currently in the Court of Appeals. We had a very disfavorable judge on at the trial level that basically didn't consider any of the arguments we raised, rejected the truth of the allegations of the complaint, which you're not allowed to do. You're supposed to, if you on a motion to dismiss for 12b6, you're supposed to accept all of the allegations in the complaint as true. And assuming the truth of those allegations, the question is whether you have stated a claim for relief that could be granted. And so we are having a hearing on October 24th at 9 a.m. in the Arizona Court of Appeals Division 1 on that issue. We have a very favorable 3-judge panel. The most conservative judges, in my opinion, in the state are going to be hearing this case. And we should get a very quick order afterwards because they have accelerated the disposition of this case. So hopefully before the November 5th election, we will have a decision as to whether Abe is going to get a trial to prove that he is, in fact, entitled to the office of Attorney General. So that would be a huge win for us.
Wow. And in that event, what would happen at that point? I mean, are we in uncharted waters at this point, or do we have any idea?
Well, this has never been done before, as far as I know, in Arizona's history. But the quo warranto action has long been recognized as a valid way to kick someone out of office who is unlawfully holding that office when someone else has a superior title to the office. So basically, Abe lost by 280 votes. We have irrefutable evidence that Maricopa County accepted hundreds of thousands of ballots in violation of the non-technical signature verification law in Arizona. And we believe wholeheartedly that we're actually going to put Abe in office very soon. So
wow, that would be something.
Yeah, it's a really wonderful case. The Arizona Constitution, going back to constitutional law, is very progressive. It was adopted as the 48th state. We adopted it after all of these other states had passed their constitutions. And our constitution uniquely provides rights to voters that are not found in other state constitutions. For example, the person elected must be declared the winner based on the highest number of legal votes. That's from Article 7, I believe it's Section 7. And then there are other constitutional provisions, for example, that require registration and other laws to secure the purity of elections. And anytime you have a statute that's passed that furthers the constitutional rights of voters in Arizona under the Arizona Constitution, that's called a non-technical law. It advances your constitutional rights and secures your rights, your foundational rights. And so it's not just some sort of technicality that can be set aside or disregarded by the county. They actually have to conduct signature verification in the way the law requires. They don't get to augment the law and basically expand the category of signatures that you can utilize for signature verification, which is exactly what they did here.
in future terms, what do you feel like the Republican Party or the state legislature in general in Arizona has done to safeguard the elections, especially the upcoming election in Arizona? Do you feel like they've done any significant legislation compared to 2020, even 2022?
Yeah. So one of the things that they've done recently was the documented proof of citizenship requirement. That was a law passed in early 2023 by the state legislature. And that really does require every time that you fill out a registration record, you have to show your ID. You have to prove that you're a citizen. There were laws on the books before that as well that established that right, but they weren't as clear. So they very much clarified that requirement. For example, ARS 16152 requires that when you register to vote, you have to provide, certain enumerated list of documentation to prove that you're a citizen. ARS 16166 requires the same, and it actually says that if you don't provide proof of citizenship when you register to vote, the county recorder must reject the application. And those laws have been on the books for a long time. But in my opinion, I think the Republican Party is a weak-kneed party. I think they don't really do much to protect their constituents, and that's why I'm not a Republican. I'm a registered independent. I used to be a libertarian. I very much still have libertarian values, but I don't think that the Republican Party is saving anyone.
Another question that I had for you is with the whole forensic audit that happened. I can't remember if it was 2021 or 2022, but there was a forensic audit, a pretty extensive, it seemed like, audit that was not just a simple recount regarding the ballots and I guess what happened during the general election in 2020. Can you kind of summarize to us what exactly happened, if you know what happened with the forensic audit?
Yeah, so to the best of my knowledge, I was still in law school at the time, so this is a little bit before my election integrity involvement. But cyber ninjas, that was the audit that you're talking about. So basically, what they did is a bunch of people were claiming that the electronic voting machines were not correctly tabulating ballots, and so they got their hands on all of the original ballots that were cast, and they did a hand count. And so that was the premise of the audit, and didn't really go anywhere.
I remember it being like Arizona was in the spotlight for so long. They kept talking about Arizona. They kept focusing on this forensic audit, like prominent individuals, and nothing really ever came out of it. So I was always wondering, I had the opportunity now to ask somebody that actually knows what the heck happened, because people just dance around this whole thing. One more thing that I wanted to follow up on, or not follow up, but just ask you. So I have a friend that tells me that he believes that people who are in the country illegally can actually cast a vote in the specifically in the federal election. How true are these claims? Like, are illegal aliens actually able to access a ballot and cast their vote for, Kamala or Trump or whatever it is?
It's 100% possible.
Wow.
Again, going back to the federal only form, which is the standard requirement across the country. If you want to vote in a federal election, you do not have to provide documented proof of citizenship. All you have to do is check a box saying that you are a citizen under penalty of perjury. And I mean, in my view, if you're willing to cross the border illegally, then what's to stop you from illegally voting in the election? So I think that we should probably change the federal law, which is what's necessary to fix that problem.
And how easy is it to find these cases and to prosecute them? Or maybe it's the opposite. How hard is it to actually find these cases? If it's an individual that voted that wasn't eligible to vote, can we actually find this in the system?
It's nearly impossible to find those specific instances. The problem is in litigation, that's election fraud. And so when you need to understand the burdens of proof and the allegations that you're making. So if you're talking about fraud, for example, as opposed to malfeasance or maladministration, election misconduct, those types of claims, when you allege fraud, you actually heighten the standard of proof that you have to prevail on. You go from preponderance of the evidence, is it more likely than not that what you're alleging is true, to I have to establish by clear and convincing evidence that what I'm alleging is true. And so without actually having a giant stack of affidavits from people who know firsthand that all of these individuals listed voted and they voted for this candidate, you can't prove it. So it's much easier, in my opinion, and that this is what I do, is I find laws that further the constitutional rights of voters. I look for the way the election is conducted. I examine that from a very broad perspective. And I look for violations of those non-technical laws. And I make allegations based on that in the election litigation that I do.
Wow. That is a lot of work. I'd like to kind of switch gears and talk about the Second Amendment. I wanted to ask, where's the legal line between reasonable regulation and an infringement of rights? Because I know that the left has been talking about this for years and years. They want to get rid of our rights or take away our guns. But where do you see that line, and what can be done about it?
It's a very blurred line, and that line has been blurred by the Supreme Court of the United States in numerous cases over the nation's history with respect to limitations on the right to bear arms. Basically where it stands now is you can impose reasonable, whatever the hell that means, restrictions on certain types of firearms. So, for example, you can limit a person's capacity to have a machine gun, a gun of war, a bazooka, a rocket launcher, those types of things. You can't own as a citizen. And the government actually can legislate and restrict your rights to own those types of firearms, but they can't over broadly restrict your right to actually own a firearm and defend yourself. So there have been cases, for example, in New York, where individual citizens were told they can't carry their guns in public. I believe those cases have been struck down by the Supreme Court. Those types of ordinances, you're able to basically bear arms in most places. Certain limitations, obviously, schools, government buildings, things of that nature, you can put limitations on. Private businesses can also, through their contractual rights, limit people's capacity to bear firearms. So if you see a no firearms sign on a store, I recommend you do not carry a gun in there, because if you do and something happens, you can be sued. So it's really a blurred line. There are other organizations that are out there that really focus on the Second Amendment. That's not really my niche area of constitutional law, but it is a very interesting area, and I'd be happy to take on cases if anyone wants to litigate any Second Amendment issues. I'm happy to do the research and file the pleadings.
Yeah, it's interesting because I've seen that the Supreme Court struck down some laws that California was trying to get pushed. I believe it was regarding whether it's bump stocks or assault rifles or something, and they've been struck down. And I can't specifically tell you what they were. Maybe you know better than I do. But it seems like California, which has the strictest gun laws in the nation, where I live, has been losing against these infringements of the Second Amendment. And I don't know where they're at right now. Do you have any idea of what's going on with that, or where we are?
The Supreme Court is a very conservative court right now. We have a lot of great justices on the Supreme Court that are very protective of our constitutional rights. They employ what's called a textualist approach, an originalist approach. And what that means is that they look at the Constitution and they look at the meaning of the words written in the Constitution at the time that document was actually adopted. And they use that interpretation instead of today's interpretation, which is more of a cosmic constitutional theory, the evolving rights of the Constitution based on what's changed in society to protect our rights. And so that has been a very big blessing for us, that we have such a strong textualist court, a strong originalist court. And I believe that we will have the right to bear arms pretty much indefinitely with certain limited restrictions on it. So I don't know exactly the specifics of the cases that have been going up recently. I'm going off of my memory from law school, in essence. I haven't litigated any of these cases recently. So,
and I have a quick question regarding the Second Amendment. In a hypothetical scenario where U.S. Congress gets together and passes some sort of legislation that does infringe on the Second Amendment, perhaps let's say they want to do a complete total ban on guns, would that supersede the Second Amendment because U.S. Congress essentially passed that law, or the Supreme Court still be able to strike it down if they deem it to be unconstitutional? How does this exactly work, if you know?
Yeah, so going back to what I said at the beginning of this podcast, the most important thing to remember is the Constitution is the foundation upon which all other laws must be based. And anything that exceeds the foundation, goes beyond that, and actually violates the rights established by that document is unconstitutional. So let's say, for example, in your scenario, that U.S. Congress passed some sort of law banning handguns in the United States. No one can own a handgun. No one can own a gun. In that case, it would be struck down as unconstitutional by the Supreme Court because it would violate the Second Amendment.
That makes sense. Okay. I want to circle back to election briefly, I promise. So certain individuals in the states went around the state legislature by implementing sort of laws under the guise of a COVID emergency that changed the state's election laws. Is that legal to do? Are you able to go around the state legislature? Is that
It depends on which state you're in and who's sitting on the Supreme Court of that state. So election laws generally are left to the states. You, as the state legislature, have the right to set the means, the way in which the election is conducted. And what happened during COVID, let's say, for example, in Pennsylvania, the law was changed. Basically, the individuals running the elections, the Secretary of State, and those folks decided to implement, mail-in ballots across the board, even though there was no statutory authority to do so. And the Supreme Court in that case, the state Supreme Court, held that because of the emergency, they had the right to do this. In essence, there really was no foundational basis to hang their hat on with respect to that opinion. They just kind of did it. And that's why it's important to know who your judges are, who your Supreme Court justices are in your state level, because those are the folks that are going to decide how elections are conducted and whether or not the laws were actually followed or violated.
Wow, that's crazy. Yeah, that's a common thing that we hear after the 2020 election, is that certain states, like my state, for example, Georgia, it totally went around the state legislature and brokered all these deals behind the scene that allowed them to usher in like a universal mail-in ballot access to any individual on the voter rolls. And these voter rolls haven't been cleaned up for 10, 15 years. And as you explained to us, in many scenarios, individuals can be on the voter rolls that aren't actually eligible. They maybe have moved. Maybe they're not citizens. So that's
dead.
See, dead. Exactly right. Like, come on now.
Yeah. Ryan, I want to talk about the First Amendment and the freedom of speech, especially when it comes to social media censorship. I've been incredibly censored. I think we were talking about it over dinner when we had dinner. For the last 9 months, they're just letting me off little by little. Today, we saw that Mark Zuckerberg just released a statement that he's now a libertarian, and he hired a strategist to amend or fix his relationship with the right or with Trump. Where are we standing now with this whole Section 230? What's the latest updates, and where do you see censorship on social media going in the future?
Yeah, so Section 230 obviously provides some protections to web-based publishers for the content that is put on there by the public. So you can't be held liable if someone goes onto your platform if they, put porn on there, for example. That's the type of thing that you're protected from as a web-based publisher. But what's really interesting now with that letter from Mark Zuckerberg, and actually there have been a few lawsuits filed in relation to that. So RFK Jr. sued, my friend Mike Yoder sued. He's another attorney, another constitutional attorney out of California. He filed a pro se complaint against Zuckerberg and against the federal government for censoring his posts and censoring his content. And what you need to establish in order to succeed in one of those cases, and what has been established now by Mark Zuckerberg's letter, is that there was collusion between the social media sites and the government actually directed the sites to take down certain posts, to censor certain citizens. So one of the things that we did recently, and we are still hoping to find more information on this, I don't believe that my public records request has been fully satisfied, is that we asked for all of the documents, all of the emails, all of the communications between the Maricopa County recorder, the Secretary of State, now the governor, former Secretary of State, between those offices and these social media companies. And we actually did find some instances where these individuals were flagging certain Twitter posts and asking Twitter to remove these people from the platform, actually censor them, delete their posts, and kick them off the platform. And we could theoretically sue the government actors for violating people's free speech rights under those circumstances because they directed the censorship, which is protected speech. So that's an option. That's what I would recommend most people to do. If you can find that connection, you really need to have that. And that's actually why the case out of Missouri, the Missouri v. Biden case, was dismissed by the Supreme Court on standing, because they didn't have any direct connection between the plaintiffs in that case who were suing and the government actually targeting those individuals and having their posts removed. If they had found that, they very likely would have succeeded in that case.
I believe they're redoing that, right, with better standing. Is that right? Or
yeah. So different plaintiffs, more information. You can always litigate later on as long as the issue isn't precluded and hasn't been decided yet.
So at the moment that, let's say, X, or at the time that it was Twitter, decided to ban an individual based on certain speech that they put on their platform, and perhaps the government directed them to do that, that would mean that they are acting as a publisher, right? And no longer should receive the 230A protection? Is that how that kind of would work?
Correct. You're acting as a censor. You're actually you are controlling the content, but that's not necessarily the issue. The issue really comes down to whether it was something the government said you had to do as a social media company, or whether it's something you decided to do on your own.
Makes sense. So I guess right now, where do we stand with these social media companies that have, is there any evidence of communication with the government directing these, social media companies to remove certain speech or content, and that's somehow, taking away their 238 privileges?
Yeah, I mean, that's exactly what's happening in Mike Yoder's case is he has this letter from Zuckerberg saying that he was going around listening to the government when they told him to remove certain content. And now you have an individual who believes that he was one of the folks that was targeted and thinks he can get into discovery to actually reveal that information. And so he is suing on the theory that the government acted in collusion with the social media site to silence him. So that is the way that you would go about handling that situation as a plaintiff.
And if he's successful, what would be the outcome or the implications of this? Is there any monetary gain from this? Yeah. Okay.
And that's what you're suing for. Is you're suing for monetary damages for silencing your speech. So there's a law. It's Title 42, Section 1983 of the United States Code. This is called the Ku Klux Klan Act. It was passed in 1871. It was aimed at preventing the government from discriminating against individuals, violating their constitutional rights. And when you find that a state actor, someone who is a part of a state or someone who's part of the federal government, has violated your constitutional rights, they have censored you, they have done something to prohibit you from engaging in free speech, then you as an individual actually can sue that person personally for damages and hold that person accountable. That's exactly what we're doing in these masking cases. We're claiming that because these people were acting under color and authority of law, they were, acting pursuant to the school mandates and silencing the speech of our clients, they are personally liable for damages based on what they did to those folks. And you can get punitive damages too if you make the right allegations and you prove it. So you can actually get millions of dollars theoretically to hold these folks accountable. And that's what we're asking for. The whole point of the Gavel Project, when I started it back in October of 2021, I saw our country falling apart. I think you guys still see that happening today. And I believe wholeheartedly that we are spiraling very quickly towards violence, towards widespread, basically civil war. And the motto, the catchphrase of the Gavel Project is better a gavel than a gun. And that's because I want to do everything that I can right now to make sure that my kids aren't living in abject violence, which is what's coming very quickly. So the only way that we can protect ourselves and ensure that doesn't happen is go to the courts, ask the courts for redress of the grievances that have been committed upon us. So that's what we're doing.
That's amazing. And so people can get a hold of you. Maybe they have something that they'd like to run by you, get your advice on, or potentially have a lawsuit. How could they find you? I know you said it before, but just to get it out there again.
Yeah, so there are a number of ways that you can get a hold of me. I'm on Twitter at Ryan_L_Heath. That's where I spend most of my time on social media. You can find me at heathlaw.com. And if you want to give to the Gavel Project, if you have the capacity to do so, we really do need the support. Again, we run exclusively on donations from individual people like yourself, tax-deductible donations. And we're the ones on the front line holding these folks accountable. So you can go to thegavelproject.com. Again, that's thegavelproject.com. And we really do appreciate the help. It's extremely expensive to hire attorneys. I know personally, I charge quite a lot per hour when I'm giving legal advice in my private practice. And it's no different when we're hiring attorneys to represent the interests of these kids. So, a couple $100 an hour very easily, and it gets burned fast. So if you have the resources and you want to make sure that we're continuing to fight, please consider making a donation.
Yeah. And again, it's tax deductible. So if you're listening to this, instead of giving your money to the government, give it to some good place like the Gavel Project.
That's right. Thank you.
Yeah. Yeah.
Thank you so much, Ryan, for coming on, and we appreciate the free legal conversation.
One more thing I think people can check out is thegavelproject.substack.com. I do talk quite a bit about different constitutional issues there. I talk about the lawsuits that we have and what Fabian was just alluding to, my theory, which I haven't been sued for defamation for, despite naming the people involved at a very large university that were colluding to basically control the narrative around COVID and maximize profits for Wall Street.
Wow. Well, we'll definitely have to have that conversation very soon. Thank you so much, Ryan. We really appreciate your time.